story that we've been leading with throughout the day. The Public Protector's Office, which has been ordered to pay 85% of the legal costs in the Estina Dairy Farm report case. The DA and the Council for the Advancement of South African Constitution applied to have the report set aside, arguing some senior officials were not probed. So the High Court found that Mkhwebane failed South Africans in how she dealt with the investigation. We've got CASEC's Executive Secretary Lawson Knight, who joins us now via our Cape Town studios. Lawson, thanks a lot for joining us this afternoon. Would you say that you are vindicated at the ruling?
Well, indeed we are. I mean, I think this part of the judgment regarding the personal cost order, which we had requested from the court, is a vindication of our belief that the Public Protector did not execute her constitutional responsibilities adequately in finalizing the report on the Estina Dairy Farm project, that she changed significant parts of the remedial action from the provisional report without providing the court with an adequate explanation as to why she did that. And I think it is on that basis that the judge today described the performance of Advocate Mkhwebane as being grossly negligent and therefore leading to this cost order.
I mean, in that sense, Lawson, would you say that she's on an agenda, perhaps to advance the needs or to advance the agenda of certain factions within the African National Congress?
Well, I think this is certainly an assumption that that is being led to because of the way the Public Protector has conducted herself. As I say, in terms of changing the remedial action in this particular report, what she did was to prevent further investigation of high-ranking political officials in the Free State Province, high-ranking civil servants as well. And it was only after the court application was instituted that the Public Protector then went to Parliament and agreed that she would reopen the investigation into the involvement of those people. But again, without providing the court with an adequate explanation as to why she failed to do that previously when it was within her responsibility and indeed it was her duty to follow all the leads that the investigation led to.
Well, of course, the spokesperson came out and said that they'll be appealing the actual judgment in itself and said that actually the Public Protector acted in good faith. How do you feel about that?
Well, I think reading of the two judgments, and I think the important thing is that today's judgment in relation to the cost order has to be read in tandem with the judgment that Judge Tolmay handed out in May this year on the merits of the case, which goes into detail as to why that report was reviewed, declared to be irrational and set aside. And I think the conduct of the Public Protector in this whole matter is something that the court has frowned upon and has deemed it to be not up to the standard that one expects of a person holding such a high constitutional office. I think Judge Tolmay has followed the direction that's given to her by the Constitutional Court in the Reserve Bank case, where it was decided a few weeks ago with regards to the responsibility of public officials for personal cost orders, and that the judge has now applied that law to the facts of this case. So in those circumstances, I really don't think there's much of a chance that any other court will come to a different conclusion, and I would not be surprised if leave to appeal were not to be granted in this matter.
Lawson, I must ask you, at this particular moment in time, it's becoming very expensive to be a public protector in the South African context. So in that regard, do you think that she should just bow out, or do you think that actually something should be done and she should be fired?
Well, I mean, I think, you know, this, the list of cases and judgments that are going against the Public Protector is growing by almost by the week. And I think these judgments call into question quite seriously the capacity and the competence of Advocate Mkhwebane to continue to hold office. And I think, you know, if she was guided morally and ethically in the right way, she would step down without further ado. But if she fails to do that, then we certainly think that Parliament has a responsibility to expedite the inquiry into her fitness to hold office and to take steps to remove her from office as soon as possible.
Do you think South Africans care at this particular moment in time? And I'm saying that because you and I are having a conversation about it. It might be, you know, an intellectual conversation around the Public Protector as well as the findings and the judgment and the court ruling against her. But ultimately, the people that have to pay for those expenses, especially in the capacity of her office, are the taxpayers. Are the taxpayers aware and do they care that this is where the money is going to be going to?
Well, I think that they do, and I think the judge today pointed to another aspect of this case, that, which was that the public protector appointed 2 different sets of counsel, 5 advocates in total, to defend the two applications brought by CASAC and the Democratic Alliance. And the judge said that, you know, the facts were the same, the issues at stake were the same, the law was, legal prescripts are the same, and there's no reason why the public protector should have enlisted the work of 2 sets of counsel, and that was another flagrant abuse of public resources. So I think the public ought to be concerned about the manner in which the Office of the Public Protector is being run, and the impact that is having on respect for the office, but also on the wastage of public funds, in particular now with the build-up of all of these cost orders, and reminding the public that 85% of the costs in this matter will come out of the public purse.
Well, I mean, we've got 7.5% that must actually be paid out to you in her personal capacity. Have you been given a figure in terms of exactly how much is due to you as the organization?
At this stage, we don't have that information. The legal teams will have to tally up their costs, have them properly assessed and taxed, and only then will we be able to submit to the court the costs that we incurred in the matter, and then claim back from Advocate Nkorbani in her personal capacity 7.5% of those costs.
Lawson, we're going to leave it there for this afternoon, but thanks a lot for joining us and shedding some light in terms of your sentiments regarding that judgment against Public Protector Busisiwe Mkhwebane. Lawson.